for joining me today. In this video, I will be talking about individuals that omit information about their criminal past and the consequences that can actually come as a result of doing so. If an individual decides to omit any information from an immigration officer with regards to their criminal past, the consequences can actually be quite severe. It is very important to be as straightforward as you can with immigration officers, especially with regards to criminal past, as they do have information and the ability to find out this information on their own. You should tell the immigration officer any information about your criminal past, even if it is a minor charge. The immigration officer will most likely probe or ask you questions about a criminal past if they have seen any information in their database. This usually happens in the pre-screening of your passport. It is important to remember that even if you do disclose this information to the immigration officer, they do have the authority and the right to deny your entry into Canada due to possible criminal inadmissibility. However, there are ways for you to prevent this from happening. So, for example, you can apply for a temporary resident permit or a criminal rehabilitation application in order to overcome your inadmissibility. If you have an approved temporary resident permit or a criminal rehabilitation, you would actually be able to enter Canada with your inadmissibility issues. On the other hand, if you decide to not disclose this information to the immigration officer and they find out that there is sufficient information about your criminal past, the consequences that can ensue can be actually quite severe. For instance, they might actually charge you with misrepresentation. The definition of misrepresentation is actually the non-disclosure of accurate information. Therefore, if an individual decides to lie or omit information from an immigration officer, they are in fact counteracting the proper legislation of the Immigration and Refugee Protection Act, also known as IRPA. If an individual is charged with misrepresentation, the worst case scenario is that they are banned from Canada for a minimum of 5 years. Another consequence that can ensue from misrepresentation is a permanent record of fraud or misrepresentation with Immigration, Refugees, and Citizenship Canada. Moreover, if you are a permanent resident or a temporary resident of Canada, you can have your status revoked. In the worst case scenario, if you are charged with misrepresentation, you can be criminally charged. Therefore, you should remember that providing immigration officers with right and accurate information often leads to less consequences compared to if you were to give an immigration officer inaccurate, inconsistent, or incomplete information. Please note that having a misrepresentation allegation on your record can lead to difficulties in entering Canada. Ultimately, if you do have a criminal record or a criminal past, it is best to overcome your criminal inadmissibility by applying for a temporary resident permit or a criminal rehabilitation application before you tell the officer about your criminal past. It is essential that you have taken all of the aforementioned factors into consideration, especially if you have a criminal past. Here at Akrami & Associates, we have dealt with many different immigration matters, and we have helped many of our clients with criminal inadmissibility to Canada actually enter Canada with either a temporary resident permit or a criminal rehabilitation. If you feel like you may be eligible for one of these applications, please do contact us. With Akrami & Associates, there's always a way.